Good evening. I am Praveena Gautam, advocate on record, and today I am here to discuss with you the paper 4 of AOR exam, leading cases. I am delighted to be associated with ILM for the guidance of the aspiring advocates to take up the AOR exam. So AOR exam is taken up, conducted by the Supreme Court every year and once in a year. So while discussing leading case paper 4, which is a very important and exhaustive paper in your exam, there are about 85 to 90 judgments which are there in the syllabus, and each judgment is a landmark judgment right from the times when the Supreme Court was first constituted. Now, it is recommended to all the aspiring advocates to prepare for this leading cases AOR exam thoroughly and must go through at least the head notes of the Supreme Court reports instead of going through any other journal. And leading cases exam basically has all the judgments which decides some constitutionality of some legislature passed, or where some ratio has been laid down, or there is some other landmark decision. These are the leading cases. Now, leading cases, one can say, is covered under Article 143 of the Constitution, where the courts are invited to interpret the law under challenge. We can divide the leading cases paper into various categories. Like the first category, which I am going to discuss today, is role and importance of leading cases in Supreme Court practice. The doctrine of precedent is a fundamental to Supreme Court practice. Article 141 of the Constitution states that the law established by the Supreme Court is binding on all the courts in India. Therefore, practice in the Supreme Court largely relies on the precedents laid down by it in various judgments. The advocate needs to identify, interpret, and apply the ratio decidendi of all the key judgments accurately, including the majority view and the minority view. And also, if possible, I would advise all the aspiring advocates to go through the arguments put forth by both the parties to understand the ratio decidendi of a judgment. Paper 4 of leading cases of AOR examination basically assesses the candidate's understanding of the development of legal principles. It also tests their ability to differentiate between ratio decidendi and the obiter dicta, or whether it has been passed just like that, along with applying established law to a new situations. The focus in this paper is not on summarizing the facts, but on showing the clarity in doctrine and skill and interpretation. You can refer to few cases so far as the ratio decidendi and importance of precedent uh, uh, passed by the Supreme Court is Union of India versus Raghubir Singh, which was decided in 1989, which highlights the importance of certainty and consistency in the precedent. Similarly, Supreme Court in State of Orissa versus Sudhanshu Shekhar Mishra, decided in 1968, established that a judgment is authoritative only for what it decides and not for what it can be logically inferred. So, therefore, it is very important to read the judgment and cull out or find out what actually has been held in the given circumstances. Number two is doctrine of precedent, ratio decidendi, and obiter dicta. Ratio decidendi refers to the legal principle on which the case is decided and can be applied to the cases which are going to be decided after that, and is a binding under Article 141. While obiter dicta is a persuasive or a passing reference, they are not binding. A practitioner must be skilled in isolating the ratio decidendi by looking at the relevant facts and the legal issue at hands, and also the arguments put forth by both the parties. Therefore, my emphasis is not only reading the conclusion in a judgment, you must read what has been put forth by the arguments put forth by both the parties, the minority view as well as the majority view as well as the minority view, to find out what is the ratio decidendi in a judgment. The court strongly discourages misapplication of precedents by quoting isolated observations without proper context. You can refer to the judgment of Quinn versus Latham, which was decided much prior to the Supreme Court in 1901, which said that every judgment must be understood in the context of its own facts. The other judgment which one can refer to was decided in 2002, Director of Settlements versus M.R. Apparao, which clarifies the binding nature of the ratio of a judgment under Article 141 of the Constitution. The second category, we can take it as landmark constitutional cases where the issue of basic structure of the constitution is involved, where it says that you cannot touch the basic structure of the constitution while passing a legislation. The basic structure doctrine is a key aspect of Indian constitutional law. It limits parliament's power to amend the constitution under Article 368. The leading cases which can be referred to is the celebrity case of Keshavanand Bharti versus State of Kerala, where the court ruled that the parliament cannot change the constitution's basic structure. The other celebrated judgment is Indira Nehru Gandhi versus Raj Narayan, decided in 1975, which identified the rule of law and free elections as part of the basic structure of the constitution. Similarly, Minerva Mills versus Union of India, decided in 1980, following Keshavanand Bharti and Indira Gandhi versus Raj Narayan case, again established that the harmony between the fundamental rights and directive principles of state policy is part of the basic structure of constitution, and the legislature cannot touch it while amending the constitution. The second category in the constitutional judgments is the judicial review and separation of powers. Judicial review is a vital feature of constitution and part of its foundational structure. The case laws which you can refer to in this regard are SP Sampath Kumar versus Union of India, decided in 1987. The court stated that the judicial review cannot be weakened. Similarly, L. Chandra Kumar versus Union of India, decided in 1997, established that the power of judicial reviews vested in the High Court and cannot be removed from the high courts and cannot be removed from the Supreme Court while deciding a case under Article 226. The category thereafter we come to is the fundamental rights and the jurisprudence thereto. The Article 14 gives a equality before law. So Article 14 prevents arbitrary actions and ensures equality before law. Authorities cannot take any decision which infringes the right under Article 14 given to each of the citizens of the country. One can refer to E.P. Royappa versus State of Tamil Nadu, decided in 1974, which established that the arbitrariness contradicts equality. If there is some order which is passed and is arbitrary to the rights of a citizen, does not give equality on the same footing, can be challenged before the Supreme Court. Before the Supreme Court. Now, the other judgment in this regard can be referred to as Menaka Gandhi versus Union of India, where the passport of Menaka Gandhi was impounded on arbitrary action of the authorities. In 1978, Menaka Gandhi filed a writ petition challenging the action of the passport authorities, that my passport has been impounded arbitrarily and which is violation of my fundamental rights. So that case demonstrated the connection between Article 14, 19 and 21, fundamental rights, equality and liberty before the law. Article 21 speaks about right to life and personal liberty. And the leading cases which can be referred under Article 21, which broadly interpreted to include various substantive and procedural rights, are A.K. Gopalan versus State of Madhya Pradesh, which was decided in 1950. The case had a narrow interpretation which has been since been relaxed in Menaka Gandhi's case, as cited earlier, as well as in a recent case in 2017 in KS Puttuswamy versus Union of India, which decided that and recognized the right to privacy as a fundamental right. Next comes the writ jurisdiction and public interest litigation in the leading cases section. The writ jurisdiction under Article 226 and 32 of the Constitution of India developed to address social injustice through public interest litigation, which relaxes the traditional rules of locus standi. So, anyone who thinks that there is some public interest involved at large, one can always knock the doors of the court to seek justice. So, cases which can be referred in this is Romesh Thapar versus State of Madhya Pradesh, a writ petition filed under Article 32, and it is the heart and soul of the Constitution. Similarly, in Bandhwa Mukti Morcha versus Union of India, 1984, it was again a PIL which identified as a tool for achieving social justice, as well as State of Uttaranchal versus Balwant Singh Shofal, which was decided in 2010. The court provided guidelines to prove misuse of PIL. The other part of leading cases we come to is federalism and center state relations. Federalism is a part of the Constitution's basic structure. The Supreme Court plays an important role in upholding the balance. The leading cases which can be referred to in federalism and center and state relations is S.R. Bommai versus Union of India. This case confirmed the judicial review of President's rule and reaffirmed federalism, and was decided in 1994. The other case which decided the limits of judicial review in political matters was State of Rajasthan versus Union of India, decided in 1977. The leading cases in the category of administrative law and natural justice, where it was decided that the principles of natural justice, such as Audi Alteram Partem and Nemo Judex in Causa Sua, are essential in decision making process. The leading case one can refer to is A.K. Kripak versus Union of India, decided in 1969, where natural justice principles, where it was said that natural justice principles apply to administrative actions as well. It again, the principles of Audi Alteram Partem was discussed at length in the judgment of Menaka Gandhi versus Union of India, where it was held that fairness was recognized as a part of the procedure under Article 21. The leading cases in the category of civil law and procedural jurisprudence, the first case is on the topic of res judicata and finality. The Dairo versus State of UP, decided in 1962, held that the principle of res judicata applies to writs. That means it does not only apply in the civil cases under CPC, but it also applies to the writs where a writ filed for the same cause of action cannot be filed again arising out of the same cause of action. In Kunya Ahmed versus State of Kerala, decided in 2000, it was again clarified by the Honorable Supreme Court that the effect of dismissing a special leave petition, if a SLP against the same impugned order has been dismissed, the second SLP on the same against the same impugned order cannot be maintained, and the principles of res judicata and finality applies to the SLP as well. In the civil law, we can also discuss the leading cases of interim relief and stay orders, where the Honorable Supreme Court in M. Gurudas versus Ras Ranjan, decided in 2006, outlined the principles for interim relief, and State of Rajasthan versus Swaika Properties, decided in 1985, again outlined the principles for passing of stay orders and orders should not grant final relief. While passing the interim orders, the courts should not grant final relief. After the civil law leading cases, we come to the criminal law jurisprudence. In the criminal law jurisprudence, we can firstly discuss the leading cases in respect of bail and personal liberties. In the Supreme Court in Gudikanti Narasimhallu versus PP discussed the bail jurisprudence and Article 21, the liberty, right to liberty. In Sanjay Chandra versus CBI, the court again stated that the bail is the norm while the jail is an exception, which is being followed now in various other leading judgments. The second category in criminal law jurisprudence is the death penalty and sentencing. The celebrated case in death penalty and sentencing is Bachchan Singh versus State of Punjab, which is being followed up till now and decided in 1989. This case decided that, in fact, this case introduced the concept of rarest of rare doctrine, that the death penalty is not a rule, but you must find out the conditions which occurs in rarest conditions. So the rarest of rare doctrine was propounded in this judgment. Then in Machi Singh versus State of Punjab, the court again provided the guidelines for imposing the death penalty. In criminal jurisprudence itself, one can discuss the category of leading cases covered in contempt and judicial authority. The Supreme Court has inherent powers of contempt to uphold the dignity and authority of the judiciary. The leading cases which can be referred to in this category is EMS Namboodiripad versus TN Nambiar, 1970. This case defined the limits for fair criticism. In SCBA versus Union of India, decided in 1998, the case distinguished between the contempt powers and the disciplinary power. The Supreme Court also has now review and curative jurisprudence, has developed the curative jurisprudence by the celebrated judgment of Rupa Hurra and Ashok Hurra, where the curative jurisdiction was explained. The judgment of Lily Thomas versus Union of India, decided in 2000, addressed the scope of the narrow scope of review, and it laid down certain principles for entertaining the review petition filed in the Supreme Court. The basically review and curative jurisprudence is the finality of judgments is a fundamental aspect of justice. Therefore, not in every case, but only in exceptional cases, the remedy of review and curative petitions can be exercised to correct the serious injustices caused to the party. This is a brief introduction to the leading cases paper. Leading cases paper, as I already said, that it's a very exhaustive paper. It's an open book paper where you will be provided open book to read the judgments. But the whole task is how to read the judgment, how to note down what are the actual facts, what is under challenge, what is argued by both the parties, what is the ratio decidendi, and what is obiter dicta, and also read if there is a minority view. So for answering every question in the leading cases, you must divide the judgment into these parts. And I know it's very difficult to go through all these judgments. Therefore, I suggested that you must go through Supreme Court reports whose head notes are very crisp and to the point. Make your notes to do that. Understanding the judgment is very important to attempt the paper of leading cases. There are basically 4 to 5 sections of the leading question paper, which also have questions on what the judgment has held, what were the arguments put forth, what is obiter dicta, what is ratio decidendi, and what is the merit, efficiency, equality, and distinct concepts of the question of law decided in a particular judgment. So that is all for the day. I hope that we will have some session where we can actually take up 2 or 3 judgments to discuss them in detail and how to attempt a question paper of leading cases. Thank you so much.